Good afternoon, everybody. My name's David Garner. I am a capital law in Cardiff and do a lot of work for BMA Law. I'm a commercial litigator, but a large part of my practice is dealing with partnership disputes and business ownership disputes, particularly from the partnership side in the context of GP partnerships. So yeah, welcome today. I'm just going to sort of run through exactly what we're going to cover today. So firstly, we're going to just look at the common types of partnership disputes that we see in practice, in my experience. I'm going to go on to look at how partnership disputes can be avoided if possible and how they can be resolved at an early stage. We're then going to look at touch briefly on the importance of a partnership agreement, although today's webinar isn't going to go into depth about that. Fourthly, we're going to look at some potential outcomes that we often see in practice. And then fifthly, we're going to look at sort of other key considerations in the context of these types of disputes. So moving on to the common types of disputes that we see in practice. So most of the partnership disputes we see are usually to do with sort of similar type themes. So control or management of the partnership. You might have somebody who is asserting control in a manner which other partners disagree with. It might be that there's a senior partner position, and the other partners don't necessarily think that senior partner is acting as they should. So a lot of those types of disputes do come down to sort of personality as well. A lot of the disputes concern money. So, for example, it might be a disagreement concerning one partner not contributing to the practice as much as the others. There may be issues with sort of notional rents in relation to the premises. There may also be disputes as to, an outgoing partner and how much they're entitled to be paid when they leave. A big thing is personalities as well. Obviously, the fundamental basis of operating in partnership is that trust and confidence between the partners. And when you're working in such a tight-knit group and you've got different personality types, there can often be conflict as a result of that. Different management type styles as well. So some disputes involve that as well. Another thing in the context of GP partnerships is alleged misconduct and clinical investigation. So, for example, you might have a partner who's under the investigation from the GMC, maybe for something that's related to their patient care, but also it could be something completely unrelated to their work. So, if there's sort of criminal allegations against them that are unconnected to their position in the partnership. Another thing that often creeps up is alleged breaches of the partnership agreement. So it could be the case that a partner hasn't been provided with full access to certain records of the partnership or something like that, and they're accusing the other partners of breaching the terms of the partnership agreement. That's just one example of that sort of dispute. A big one for us as well is in the context of expulsions. So I'll go on to talk a bit about expulsions in a minute, but effectively, the right to expel a partner, it's only available if a partnership agreement expressly allows that, and the courts will look at expulsion clauses very strictly. So if there's been any sort of deviation from the provisions in the partnership agreement around expulsion, then that can lead to allegations of wrongful expulsion or something like that. Another example might be if the grounds that the partners are relying on are sort of subjective, in the sense that there are potential defences to them. That might be another sort of area where an expulsion might be challenged. I've put something on the slide there about discrimination as well. So if there's any suggestion that a partner has been removed from the partnership based on discriminatory conduct, but that's connected to a protected characteristic under the Equality Act, then that can give rise to challenge as well. We're often involved as well in disputes concerning retirement. So it might be the case that there's disagreement as to how much a partner is going to be paid. It might be the case that there's disagreement as to how a property needs to be valued. Usually a partnership agreement will set out the mechanism for valuation, but often that can be ambiguous, or there's nothing in sort of prescriptive in the partnership agreement. So, there could be a dispute around that. And lastly, disputes as to what governs the partnership. So, for example, it might be that there's a partnership agreement that's unsigned or not dated or not signed by all partners, and there could be ambiguity as to whether all of the partners have agreed that agreement. So, it then involves an analysis of whether that partnership agreement actually governs the practice, or whether it's whether it's a partnership at will, or a previous partnership agreement or something like that. So this isn't an exhaustive list of the types of disputes that we see, but just as sort of an example of what we do often see in practice and often deal with. A common theme in these types of disputes is that they often stem from a lack of communication between the partners. And I'll come on to sort of cover how one way of resolving partnership disputes can be to obviously get around the table, and how effective communication can be between the partners. And it's really it's really important that these things are talked about, because what we often see is that the parties do become entrenched in their positions over time, and in a sector that's under increasing pressure and demand, these disputes can take up a lot of time. Obviously, if lawyers are involved, lawyers need to take instructions from partners as to what their position is. You might have to spend days giving witness evidence and things like that. So obviously, the earlier they can be dealt with, the better. Just moving on to some ways that we can, that these types of disputes can be sort of early doors. As I said earlier, so early and effective communication is really key. Especially if the partners have an amicable relationship. So obviously, the more amicable the relationship, the easier it is to get around the table and to just have a chat about these things, as openly as possible. And often, I imagine there's lots of partnership disputes that don't even get to lawyers, because there's a method of resolution in terms of openness within a partnership. Legal advice at an early stage is also key, and I don't just say that because I'm a lawyer and it sort of keeps me in a job. I say that because what we do often see is that we're instructed sort of later down the line when things have escalated, and it can be beneficial to have preemptive advice. One example might be in the context of an expulsion. As I said, it might be better to get advice as to whether there are grounds to expel and what the potential risks are before you press the button. Because what you do, you'll probably like to save costs than if you expel somebody and then that expulsion is challenged and there's some form of litigation between the parties where they're both spending legal costs. So legal advice at an early stage is really beneficial. I say they're laying the groundwork as well. It's really important that partnership agreements have a really clear mechanism for resolving disputes. And you can't always assume things are going to be hunky dory, even if you get on at the outset, or even if you're getting on now. It's much better to agree a mechanism of resolving a dispute, or what should be done in certain circumstances when everybody's getting along, obviously in the hope that it won't have to be used. But what you don't want to do is end up in a situation where there's no agreement between the parties in that respect. The party says this should be done. So it's laying the groundwork when there is that amicable relationship there is really key. And see as well that the LMC can be of assistance. I mean, those of you at this webinar may have different views, but we often see the LMC becoming involved as sort of on an informal basis, and to not to mediate between the parties, not from a legal perspective, but just be a sort of that independent party, an independent person in the room who can sort of bounce ideas off, the parties can bounce ideas off, etc., on an impartial basis. And that can be really beneficial. And finally, just ensuring that there's a really well drafted partnership agreement. And I'll come on to talk about that a bit better. But certainly a lot of the disputes we deal with are surrounding ambiguity of partnership agreements, and there's a dispute as to what means what. So the clearer the partnership agreement and the more thorough it is and the more up to date it is, the better. Just moving on to the importance of an effective partnership agreement. So it will go without saying that a partnership agreement that's up to date is really key. As I said earlier, a lot of the disputes we see are where there's been incoming partners that have joined the partnership and they haven't seen the partnership agreement, or they've not been given a copy, they've not agreed to be bound by it. And so it's really important to make sure that the partnership agreement is reviewed regularly and kept up to date. I've highlighted on this slide some of the sort of the key things we would like to see in a partnership agreement generally. So one of those is effective dispute resolution clauses. As I said earlier, it's much easier to agree on the mechanism for resolving a dispute when everybody is getting along than it is later down the line when there's a bit of a dispute. And so effective dispute resolution clauses can be really, really key. A lot of the ones we see involve a requirement for there to be compulsory mediation at an early stage. So before the dispute can be escalated to court or arbitration or something like that, there's a requirement that the partners have to have mediated before that can be done. So it sort of enables the parties to maybe focus their efforts on a resolution at an early stage rather than being, going in all guns blazing in terms of potential litigation. Secondly, expulsion clauses as well. The default position under the 1890 Partnership Act is that it doesn't provide for a lot of things, but it doesn't provide for expulsion. So, unless the partnership agreement includes a right to expel, then it wouldn't be a right that's open to the partners. So most partnership agreements these days include an expulsion clause. They do differ from partnership agreement to partnership agreement in terms of how detailed they are and what they include, but usually you would see reference to the grounds on which an expulsion can be executed. So examples might be where there's been a serious and persistent breach of the partnership agreement, where there's been a conviction of a criminal offence, something like that, where a GP has been taken off the performers list. And usually, as I said, they will set out specific grounds for partners to rely on. Often as well, there are the partnership agreements, as I said, differ from one agreement to the next, but there can be no fault expulsion clauses as well, what are known as sort of green socks clauses, and they can be quite useful in certain circumstances if they're exercised properly. I said earlier that expulsion clauses are sort of expulsion is seen as a bit of a draconian measure by the court, because obviously it's depriving somebody of their work. So in order, when one is thinking about an expulsion, it's key to look at the terms of the partnership agreement and, make sure that you're aware of what needs to be done to affect that. And certainly where that, legal advice is really beneficial as to whether the grounds that or the circumstances that exist are strong enough to warrant an expulsion. If an expulsion is, if a partner is expelled and there are grounds to suggest there's been some sort of wrongful expulsion, then it can lead to claims in damages for loss of earnings and that side of things. So it's not a particularly settled area of law, but I have been involved in situations where partners have had £500,000 worth of damages, based on their loss of earnings for a 2 or 3 year period as a result of a wrongful expulsion. So it's really key to make sure that you're aware of the requirements of the expulsion clause that you're seeking to rely on. Another key thing that we see in partnership agreements is restrictive covenants for outgoing partners. Now, it very much depends, I suppose, on the stage of the outgoing partner's career in terms of whether they're retiring and intending to retire permanently, or whether they're leaving and then going somewhere else. It might be the case that there needs to be some sort of restriction on them contacting patients or contacting members of staff of the partnership they're leaving. So restrictive covenants can do that, provided they're reasonably proportionate to protection of legitimate business interest. It's also really key to ensure that the partnership agreement effectively and clearly sets out the partner's obligations and duties towards one another and the partnership. There's lots of implied duties in partnership law in terms of the duty to give a full account to your co-partners, the duty to be honest with each other. But if the nature of the partnership or the nature of the work that's been undertaken is such that there needs to be other express duties, then it's really clear that it's really important that the partnership agreement includes that. Sort of, I suppose, slightly linked to expulsion. Often partnership agreements these days include provision for suspension as well. And that is really useful for investigatory purposes. So, for example, if you've got a partner that's been reported to the GMC and the GMC are undertaking an investigation, that's not necessarily a particularly quick process, and you might, it might be the case that it's a better process to suspend the partner for a period of time whilst that investigation is ongoing, rather than to go down the road of a full expulsion, depending on the circumstances. So that sort of provisions, is more akin to a suspension period in employment law, but we are seeing them become more and more common. So it's something really to think about if that's not within your partnership agreement at the moment. Another key area is probationary periods for incoming partners. So a lot of partnership agreements will have, let's say, a 6-month probationary period where an incoming partner is a probationary partner for 6 months, and then there's a decision after that 6-month period as to whether they become a full partner. And it gives the partners the opportunity to review performance, ensure that any issues are ironed out, and ensure that the decision that they've made, both in terms of the decision for the incoming partner, but the decision for the other partners is the right one. And it reduces risk, really, because if there's an option for that probationary partner to leave the partnership or to go back to a salaried GP after a certain period, then it means that if there are any issues, and that process is easier than if you're, if that person is a full partner from the off, and you've then got to look at the ways of sort of expelling that person, or then retiring from the partnership. So it's that type of clause can be really helpful. Finally, deeds of adherence as well. So a lot of partnership agreements as regards incoming partners will include a requirement for any incoming partners to sign a deed of adherence. And what that is effectively is a deed which says, in sort of paraphrasing, that I've seen the partnership agreement and I agree to be bound by its terms. And it provides for certainty, because the incoming partners will be confirming that they agree to be bound on the terms of the partnership agreement, and it can avoid all these issues that might later arise in terms of whether that partner has seen the partnership agreement and whether they're bound by the terms of it. As I said earlier, a lot of our disputes will involve one partner saying certain terms apply, and another partner saying other terms apply. And where the partnership agreement isn't signed or isn't dated, or certain partners haven't agreed to it, or say they haven't agreed to it, and it's all based on verbal type communications, it can be very, very messy and very, very difficult to resolve. So you're probably beginning to see the importance of making sure that a partnership agreement is sort of regularly reviewed and updated, even particularly so if the partnership is high turnover. If there's a situation where you've got multiple partners leaving and joining, then it's really key to make sure that the partnership agreement is updated with that, for clarity. And I know that there's money associated and legal costs associated with that. But it's much better to front load that and to pay a bit of cost at the start, than have to spend lots of money on legal fees if litigation arises down the line. So a bit like sort of preemptive advice, it can be beneficial in the long run. So moving on now to sort of what the position is if a partnership agreement doesn't exist. Now, if a partnership agreement doesn't exist, then the default position would be that the partnership is what's called a partnership at will, and it's governed by the Partnership Act 1890. Now, that's not as simple as it sounds, because there can be verbal agreements. The Partnership Act 1890 allows for the partners to vary certain default provisions. So it could be the case that one part, that the partners try and argue that they varied a default provision by course of conduct or by some sort of verbal discussion. So that would come down to an analysis of the facts that are present at the time. But in terms of the default provisions of the Partnership Act, it really is quite limited, given how long ago it came into force, and it's not been updated since. So, for example, it doesn't provide any right to expel. It doesn't include any provisions dealing with maternity pay or retirement or anything like that. In the context of a retirement, effectively, a partner can dissolve a partnership by notice, and that would be a general dissolution, meaning that you could be looking at the winding up of the business. So it's really not a good place to be in, because it offers really limited protection. A lot of the disputes we see do involve partnerships at will, or partnerships where there's no written agreement, and it is, as I said, a very sort of messy place to be in, because there's no certainty there. There may be one partner saying one thing and another partner saying another thing, and it's hard really to sort of decipher what's the correct position. And certainly when there's lots of emotions floating around, it makes things quite tricky to resolve. So again, that sort of just shows how important it is to make sure that a partnership agreement is updated, certainly it's there and updated, certainly in the context of disputes as well. Because if you can say, well, if you've got a partnership agreement which is clear and sets out what the obligations are, what it's said has been breached or something like that, and what the process is for rectifying that or for resolving that dispute, it's an easier starting point than if you're trying to firstly figure out exactly what terms govern the partnership before you can even think about what can be done to resolve the situation. Just touching on some potential outcomes. So this is not an exhaustive list, but this is just sort of some of the outcomes that we often see in the context of partnership disputes from my experience. So the usual, depending on the nature of the dispute, certainly if it's a dispute around an expulsion or around retirement or something like that, the usual outcome is that one of the partners will leave, usually the partner who has been expelled and has possibly challenging that. And that would be subject to appropriate terms being agreed. That's especially the case where there's been a breakdown of the trust and confidence between the partners. And so what you'd be looking at is, possibly getting into some sort of negotiation process whereby, offers are exchanged, and there may be things that are offered that are beyond, the monetary side of things. So, talking about money, you'd be looking at, possibly payment for a notice period, payment in lieu of notice, maybe an ex gratia payment of some description, perhaps equivalent to that partner's drawings for, a month or 2 months or something, as the case may be. Now, one of my jobs really is, although I'm involved in litigation, generally speaking, my role is to resolve disputes, and the earlier they can be resolved and more cost effectively they can be resolved, the better, and ideally without the need to go to court or any form of sort of litigation. So one of the things we often see is, bearing in mind how much it would cost to issue proceedings, it might be that money is better spent on a settlement. So for example, rather than pay 10, 15, 20,000 pounds to issue proceedings and get to court, you might think, well, actually, I could put that money into the settlement pot, and the other side would be happy with that, and things would be resolved much quicker than if I go down the litigious route. So that's that sometimes can be the strategy. It might be that the partnership agreement needs to be deviated from in terms of payment of an outgoing partner. If there's a dispute between the partners, it might be that something can be agreed along the lines of, well, the partnership agreement says you shall be paid your share in XYZ, but we're going to accelerate that, out of a gesture of goodwill in order to resolve it. It might also be the case that a lump sum payment can be paid. So there are various other terms as well that you might often find in the context of potential outcomes. So what's the position with leaving accounts? Does there need to be specific leaving accounts, or do they need to be are the current year accounts apportioned based on the leaving date? What sort of indemnities need to be given? Are there any existing issues in relation to the outgoing partner? So, for example, are there investigations that might lead to damage to the partnership or loss to the partnership? Does there need to be a carve out in any agreements that any losses are indemnified by that outgoing partner. Return of property, what sort of property does the outgoing partner have that belongs to the partnership? How's that going to be returned? What's going to happen to the GMS or the PMS contract? What sort of notices need to be signed in relation to that? That becomes that obviously differs from partnership to partnership. I said earlier, so depending on the nature of the dispute, the partnership agreement might be altered to resolve matters in dispute. So it's open to the partners if they can unanimously agree to alter the terms of the partnership agreement. So it could be that a particular mechanism is altered, in order to resolve the dispute, or dispute resolution clause is altered in order to allow a resolution to be concluded. One of the big things in the legal industry at the moment, and what's talked about quite a lot, is mediation. And there's been some interesting case law recently about mandatory mediation, and it's still not particularly settled. But the courts have effectively said that in certain circumstances, the courts can effectively order mandatory mediation, depending on the nature of the dispute and the relationship between the parties. And it can be a really, really good mechanism for resolving a dispute. And that doesn't necessarily have to involve an independent mediator, in a formal mediation setting, although that is very beneficial. It could be just a negotiated roundtable meeting, perhaps, as I said earlier, with the LMC present, where you've got that independent voice of reason. You can just say, well, hang on a minute, this is all well and good, but what about the future of the practice? What about patient safety? What about continuity? Things like that. What about damage to professional reputations? So all those sorts of things need to be thought about. One of the most draconian of orders that can be sought is a dissolution of the partnership. So the Partnership Act allows a party to apply to the court for an order dissolving the partnership if there's, for example, been a breach of the terms agreed between the partners. So if there's been, if there's evidently been a breach of obligations by one partner, then it's something that the court that's open to the other partners to apply for. Now, I've not seen one of those orders being made in practice, and they are relatively rare. And certainly in the context of GP disputes, I think the court would think quite carefully before they made that sort of order. For patient safety reasons, for continuity reasons. As I said earlier, the industry is under a huge amount of pressure, so dissolving a partnership may have an adverse, or it will have an adverse consequence. So it's usually a last resort. I say I've mentioned in the slide about what's called a sire's order, and that's it's named after a case, but it enables the court to effectively order that a partner's share is brought out by the other partners, and so it could be the case that you got to court and you were seeking a dissolution, but the court said, well, actually, the better way of dealing with this is to make a sire's order, and the defaulting partner should be brought out. So that it may be an option depending on the circumstances, but really you're looking at sort of hefty costs to get there. As I said earlier, the circumstances and the nature and the constitution of the partnership will be key. It's often more difficult in two-partner firms because, by definition, if one partner leaves, they're not a partnership anymore. They become a medical practitioner or solicitor. So you've got to be thinking about what impact that has. Liaising with the integrated care board to make sure that they're all on board with that, and they're on board with a sole principal taking over the medical services contract. So there's all sorts of things to be thinking about in that context. Moving on now to the some final tips and considerations. We're doing quite well for time. I see there's a few questions, so I should be able to get to them. So just sort of, I thought it'd be useful just to touch upon some potential practical considerations and tips in the context of disputes. So first and foremost, obviously, as I said earlier, legal costs can escalate very quickly. That's particularly so once you're into the rounds of court proceedings. Depending on the value of the claim, there will be a court fee payable to issue the proceedings. Claims over 200,000, the issue fee is £10,000 just to issue the claim. That doesn't take into account legal fees of preparing the claim and everything. So you can see, how quickly fees in relation to these types of disputes can escalate. They're often quite sensitive in nature. You may have, certainly where there are allegations floating around about substandard practice and things like that. Obviously, those issues are sensitive in nature. Might involve sensitive data as well in relation to patients, and so they are issues that they are matters that need to be dealt with sensitively. They're also very time consuming. As I said earlier, as lawyers, we need to take instructions from our clients in order to properly advise. So we need to understand the background, need to understand the relationships. We need to understand the dynamics within the partnership. And so, all of that takes time out of, the GP's day, and, there could be a backlog building up as a result of these disputes. So that sort of feeds into why it's really important to make sure that disputes are dealt with really, really early on. And it feeds into my next point, that early effective communication is key. I've already said that sort of it's commonplace that, as time progresses, parties get more entrenched in their positions, so it becomes more and more difficult to resolve the situation. Somebody might have convinced themselves, rightly or wrongly, over time, that they've been treated really badly or unfairly, and they want their day in court, so to speak, or something along those lines. So the earlier a resolution can be resolved, the earlier a dispute can be resolved and resolution can be concluded, the better. And another thing as well is quite often we see disputes where something's happened, a partner's retired 4 or 5 years ago and they've not had their payout and they've not done anything about it. And since then, about 4 or 5 new partners have joined the partnership, and then you're having to sort of untangle all that's gone on since then to properly understand where they stand. So the sooner you get legal advice and the sooner that the parties can get into discussions around how things can be resolved, then the better. There's often as well, it's often worth thinking in the context of settlement discussions, what is it that's important to the other partner, beyond the monetary element. It could be that they're moving to another partnership and they need a reference. For the other party, it's not going to cost them anything. And so, thinking about whether there's any, little golden nuggets that might sort of add leverage to a deal is really important. And it might get a deal over the line, whereas without it, the parties might be sort of continuing their back and forth. I mentioned again, and I don't want to bang on about it, but how important legal advice is. Obviously, as I said, it's much better to spend a bit of money at the outset, making sure that you understand the risks of things and the risks of the next step and the options open to you, than it is to take a step without that advice and for that to be challenged and then to incur significant legal costs resolving that. One example is that I've assisted a group of 3 GPs who expelled another partner, and they came to us after that partner had challenged that decision, and flowing from that was 2 sets of arbitration proceedings, 2 sets of high court proceedings, and the circumstances were quite complex. But we're talking hundreds of thousands of pounds in legal costs that could have been avoided, if they'd been, or potentially avoided if there'd been preemptive legal advice provided. And I suppose it will go without saying that obviously the more amicable the resolution can be, the better. It means that negotiations will progress more smoothly. It means that hopefully the partners will be more sensible and more reasonable and more pragmatic in terms of what they're asking, and what they're seeking from the other side. So the more amicable the resolution can be, the better. And as lawyers, we always try and have an open dialogue with our opposing lawyer as well, just to make sure that any emotion is possibly taken out of it. Finally, I've put a little note on there about deeds of retirement. So quite often, usually in the context of disputes, if there is a resolution that's reached, it's what's called subject to contract, so in the form of a deed of retirement or a deed of settlement, and that will set out with certainty what terms are agreed. So, for example, it might be that they're going to be the outgoing partner or the partner leave by a certain date, and it can provide for instalment payments. It can add for clarity on what indemnities are being provided, what obligations might be on the outgoing partner to provide to return partnership property, or to any other obligations that might be relevant to the circumstances. And similar to a partnership agreement, the benefit of that is it allows for certainty. It means that all partners or all of the parties are on a clear in terms of where they stand and what their obligations are and what rights are open to them if if the other party's obligations are breached. So it's really key to it's a really key consideration as to whether any dispute is sort of committed to writing in terms of a deed of retirement. So that sort of ends the presentation in terms of what I wanted to talk about. I can see that I've got a few questions in the box, so I'm just going to have a look at those now and answer them if I can. So there's a question from, if a partner is involved in a civil dispute where they are known to have committed a fraud, but the case is being pursued under civil law only, what is the obligation to the partnership and the GMC as the criminal element is not being pursued? Well, I suppose it depends on the circumstances and the terms of the partnership agreement, but effectively, it could have an impact on the relationship of trust and confidence between the partners if they certainly if that fraud involves money or something like that, it could have an impact on that trust and relationship between the partners, and and it could lead to the other partners thinking, actually, we don't want to be in partnership with this person anymore. Without knowing a bit more detail about that, it's hard to give any firmer views than that, but it would depend on the circumstances of the fraud that's been committed. Obviously, unless if the situation is that there's been some sort of judgment or determination that there has been a fraud that's been committed from a civil perspective, then again that could feed into the trust and confidence element. If it's a situation where there's just allegations which are disputed, then it may be slightly different. And that I think that applies as well to the GMC in terms of if there's been some sort of judgment or determination, then the GMC may want to know about that if there are allegations of dishonesty involved in those proceedings. 3 partners own a medical centre in equal shares. Is it essential to have a declaration of trust in place for other potential future partners who won't own the building? Would a provision partnership agreement be sufficient? Generally speaking, I'm not a property lawyer, but generally speaking, the partnership, if the partnership agreement is clear as to how the property is held, then that would suffice. I say, obviously, a declaration of trust, may add further clarity. But if a partnership agreement is clear in terms of the basis on which a property or premises is held, then I think that would suffice. So what we often what we often, partnership agreements can differ from partnership to partnership, but what should be clear from partnership agreement is whether the premises is a partnership asset or whether it's an asset of the individual partners, and that they, if it's an asset to the partnership, it would usually be held in the name of, in the partners' individual names, but on trust for the partnership. If it's the latter, then you wouldn't, it would be held by the individual partners. But it's important to make sure the partnership agreement is clear about that. As I said, a declaration of trust would add further clarity, but in my view, as long as the partnership agreement is sufficiently clear as to who the premises owners are, then that would suffice. If a partner has already given notice, but during the notice period starts misbehaving, for example, booking far more holiday than entitled to, is there a way to write a penalty clause to prevent this? If you break the agreement, you'll get working capital paid out delayed by X months. It would largely depend on the terms of the partnership agreement. If a partner is, if a partner is serving a notice period and acts in a manner which is, I suppose, a breach of that partnership agreement, i.e., manner which might be conduct which might be grounds for expulsion, and there's no reason in law why they can't be expelled during their notice period. I don't think that booking more holiday than they're entitled to would necessarily equate to the grounds to expel. But what you might find, depending on the terms of the partnership agreement, is that it might be sort of an accounts, and it might fall down to leaving accounts. And if it's a situation where they've taken more holiday than they're entitled to, there might be some sort of set off. So a calculation of what in monetary terms, what additional holiday they've taken in monetary terms, which they weren't entitled to, against what they're due from the partnership, and some sort of set off process. But that would depend on the terms of the partnership agreement and what provisions are in there with leaving accounts. There's no reason there's no reason why that partner couldn't be written to effectively to say, look, we're concerned about this. If it continues, then this is what we're going to do, X, Y, Z. I don't think in the circumstances that that sort of a penalty, that a penalty type clause would be appropriate, in the sense that you delay the payout. But as I said, it might be a situation where actually it's all for in the leaving accounts in terms of the holiday, the monetary value of the holiday they've actually taken. So what if the majority have signed the agreement but one has not? All are acting according to the agreement. Well, the ideal, as I said, is to have all partners all partners present have signed the partnership agreement, because that is the best for clarity. However, if you've got a situation where one partner hasn't signed the agreement but is quite clearly acting in accordance with the terms, has previously relied on certain provisions of that partnership agreement, has the partners have effectively pursued a course of conduct, the effect of which is to demonstrate that the terms of that agreement are agreed and they're bound by them, then that would suffice. Obviously, the difficulty with those sorts of situations is evidentially is trying to come up with the evidence to show that that person has acted or pursued a course of conduct which is consistent with the terms of that agreement. There may be a lot of evidence available for that, but there may not be. So that's obviously the risk with that situation. But in principle, if all of the partners are acting in accordance with that agreement, then the argument would be that it's effectively a valid, it validly governs the partnership. And new partners join a partnership if one of the existing partners refuses to accept new partners and therefore won't sign a new agreement accepting them. Well, I suppose that depends on the terms of the partnership agreement and what how a decision around incoming partners is made. They often differ around what sort of decision-making process is necessary for an incoming partner to come into the partnership. Some are majority decisions, others are unanimous decisions. So if it's a situation where an existing partner is refusing to accept an incoming partner, or to agree that an incoming partner is necessary, and unanimous decision is necessary, then obviously that's a difficult position, and potentially that incoming partner can't come in until that unanimous decision has been made. What in those sorts of circumstances, it would come down to an analysis of what the position is. If it's a situation where the incoming partner is required for the purposes of the future of the practice, it might be that practice is overloaded with work, and it's basically a breaking point without that incoming partner coming in. Then there may be questions as to whether that existing partner's conduct is in the best interest of the partnership, is possibly a breach of his duty of good faith to other partners, and so that would require an analysis of the facts in terms of whether that person's conduct is capable of being dealt with in another way. So yeah. Speed of retirement. Who should pay for this, i.e., the ongoing partner or the retiree? Ultimately, it depends on it's rare that a partnership agreement would include a provision or would explicitly set out who pays for that sort of who pays the legal costs for that sort of work. Ultimately, it would come down to what the parties agreed. If it's a fractious retirement, then it might be something that's added into the settlement. The settlement terms, as a gesture of goodwill, the continuing partners will pay the partnership, or it'll be treated as a partnership expense. Again, it depends on circumstances, but one option we see quite frequently is that it's effectively treated as a partnership expense as at the date of retirement. So it's a partnership expense that's taken into account in the leaving accounts as well. So effectively, all of the partners sort of share a portion of it. What we suggest if a partner has not insignificant breach of the deed, but is generally not cooperating and obstructing the day-to-day running of the practice, like not signing off accounts for multiple years, with the other partners and management of practice decisions. Well, it might not be the case this person is sort of in breach of an express obligation or duty under a partnership agreement. But as I mentioned earlier, a fundamental aspect of partnership law is this duty of good faith and the duty to act honestly with each other, the duty to account to each other, and the duty to act in the best interest of the partnership and the partners. So if it's a situation where there's repeated evidence of that person deliberately not cooperating, that's causing prejudice to the partnership, then it still could be the case that there's potential grounds to do something about that in terms of an expulsion or something along those lines. Again, you'd have to make sure that right exists in the partnership agreement, and that it would come down to the evidence available and what evidence can be accumulated to demonstrate that particular conduct. But it's most partnership agreements will have some sort of situation. A lot of partnership agreements in terms of expulsion will say something along the lines of where a partner is guilty of conduct which is severe, which can prejudice the interests of the partnership. So if it's a situation where a partner's conduct is causing difficulties and is going to prejudice the partnership because it can't run properly, then it's not inconceivable that that sort of conduct would fall within that category. Again, it depends on the evidence available and the terms of the agreement, effectively. What are BMA's charges to assist in a partnership dispute? I can't really give you an answer to that now, because it really depends on the circumstances of the dispute and the level of documentation that we need to review to get a head around the background and to understand what the position is and what the objective is. So the best thing I think to do is that is to make a referral to BMA law, and then obviously we can provide an estimate of what our fees would be to assist, and it would then be over to you to decide whether you want to go ahead with that. In terms of, other than the LMC, are there other options for informal mediation for partners with disagreements? There isn't. The BMA do offer a mediation service, so it's worth contacting the BMA in relation to that. I've had situations where the ICB have stepped in as well, and somebody from the ICB has acted as a sort of a sounding board for the partners in dispute. So the LMC, the ICB might, obviously, if you're getting involved with a with a formal mediation process, then it can be the case that can be quite costly, because you've got the mediator's fees involved to think about as well. So, but yeah, the LMC, the ICB might be an option depending on their involvement. And it might be the case that there's another independent party that for example, a former partner who people. If there's a former partner on the scene who everybody respects and everyone gets along with, then there's no reason why that third party couldn't step in. And as long as they're acting independently and impartially, then that would really be the only requirement. So can a green socks clause expulsion be challenged by under the on discrimination grounds? You cannot expel me because I'm depressed and therefore I have a protected characteristic. Yes, in essence. So an expulsion can be challenged, whether it's a fault-based expulsion or whether it's a compulsory expulsion based upon compulsory retirement. It can be challenged based upon discrimination, but obviously the onus would be on the party alleging that to show that their conduct is the manner in which they've been treated and the manner in which they've been expelled is connected to that protected characteristic. I'm not an employment lawyer myself, and so but I have dealt with some claims of discrimination, so I have an understanding of it. But in the context of there are certain requirements in the Equalities Act in terms of how a mental health illness, depression, something like that, can the basis on which it can be a disability. So I think off the top of my head, it has to manifest itself for 12 months or more. So it's not inconceivable that discrimination arguments can be raised in relation to green socks clauses. But obviously, as I said, the onus would be on that individual to properly demonstrate that the conduct of the continuing partners and how they've treated that person is directly linked to that characteristic. What we have a new incoming partner. One current partner is concerned they will not pull their weight. What provisions can be added to the probationary period to ensure everyone is happy before the new partner joins? So it could be the case that the partnership agreement effectively includes provisions for performance management. That's not uncommon. Where I'd probably recommend some sort of performance management provisions, possibly some regular check-in provisions as well, to make sure that they're sort of consistently performing as they should. those sorts of things I would expect might assist in that sort of situation if everybody's happy with it. I believe somebody's asked if there's a recording that will be sent out. I believe this is going to go on YouTube, so that should answer that question. So if a partnership agreement, I think it's meant to say, does not contain a clause on annual leave during sickness, is a partner entitled to annual leave during the sickness leave? The default position, this question relates to whether a sick partner needs to pay for locum cover to cover the usual annual leave they would have taken had they been sick. So in terms of locum cover, then the default position would be whatever the partnership agreement. If the partner, the partnership agreement would usually set out whether the partnership covers the locum costs or whether it's the costs of the individual partner who's away. And what you have often connected with that is some form of locum insurance, which means that whoever has to pay that, it's covered by insurance. There are. I'd have to check the position on this on the sickness leave, because it will probably interact with to sort of statutory rights under in terms of sickness leave. So I can't answer that question right this minute, but I would happily answer it at a later date. I think we've got time for probably one. How early should a deed of retirement be considered, e.g. if a partner is stepping down in their session in the run-up to retirement but are unsure exactly when they want to retire? Do the partners want them to commit to retiring at a specific time? There's no reason why a deed of retirement couldn't be entered into as at the date the partner provides their notice, and obviously that would set out when the leaving date is, i.e. the leaving date would be whatever the date is that's specified in their notice period. The difficulty, I suppose, would be that it would be difficult to force that partner, unless there's some sort of contractual obligation under the partnership agreement for them to enter into a deed of retirement. It would be difficult to force them to do that. But there's certainly there's no reason why a deed of retirement couldn't be entered into at an early stage, and that would actually probably add for better clarity in terms of in terms of the way forward and how that outgoing partner would be treated in terms of their interest in the partnership when they eventually do leave. Is a member needed to access BMA legal advice, a membership? I don't believe it is, no. So we do have preferential rates, hourly rates for GPs who are, or for people who have a BMA membership number. But if somebody's not a member of the BMA, that doesn't preclude them from seeking legal advice from BMA law. It may just alter the hourly rates that are applied. Just a final question, which is a very short one, but the slide in relation to the slides. I do believe that everybody who's attended will be sent a copy of the presentation slides. As I said, it's the recording of this webinar is going out on YouTube at some point in the near future. So obviously look out for that if you want to, if there's anything of interest that I've discussed today that you want to revisit. I believe as well that my email address will be circulated as well. Should anyone have any questions that haven't been answered, I think I've done my best to answer most of them. Or if any questions arise after this webinar is finished, please do use that, and I will do my best to come back to you. Great. Thank you very much, everybody, for your time.